we're going to be on. Hi, everybody. Good evening. It's 6:30. My name is Rita Young, and I'm so pleased to be here tonight to talk about a really, really important topic and something that families and self-advocates are interested in having a conversation about. So before we get started, we've have a few folks that have joined us already. Please let us know where you're watching from. Yeah, folks are just starting to join. Welcome, everyone. Let us know. And we have some folks from Facebook. And so, Facebook, in order to sync with StreamYard, you have to give permission. You don't have to do that. But someone has said hello. I don't know who that is. But if you want to tell me in the chat, let me know or not. We'll have some folks hopefully on YouTube as well. And this will be archived in both places. Hi, Rebecca. How are you? All right. So tonight our topic is on supported decision-making, guardianship, and other options. Kay is watching from Lake Oconee. We have someone from Jessup. All right. Hello, Facebook. Hello, YouTube. Thanks so much. Hey, Raisa. How are you? Okay, we have folks from all over, Fayetteville, Decula. Hey, Tracy. All right, welcome, everyone. Okay. Very pleased we're going to have some folks to chat with this evening. So there were several inspirations for tonight's chat. And one of them was a couple in a virtual training series that I developed. And this was a couple of months ago who said, I'm not quite sure about guardianship. It feels very restrictive. I'm not quite sure about supported decision making. And actually, the people that inspired that conversation are in the chat box. So it's great to see them there. Hey, Jackie. The Bryants are with us too. We've got some folks from Columbus and 85 South. Well, folks, did you all see all of the smoke? We had a very smoky environment in Atlanta today in the skyline. All right, so enough about me. I think we're going to go ahead and start. We've got about 30 folks I can see on Facebook. Sometimes it's hard for me to see on YouTube, but I'm going to go ahead and start and introduce our amazing guests. First, we have DJ Jeyaram. Hi, DJ. How are you? DJ
Hello.
is an attorney at law and also a magistrate judge, and also Dana Lloyd from the GAO.
Hi, everyone.
Hello. We've got some folks joining on Facebook, I see. Hi, my lovely friends Dana and Rita. I don't know who that is, but hello to you. Let me know who that is. All right, so we have two very experienced folks that are going to be talking this afternoon or this evening, and we would welcome your questions. Sandra is listening from her car, but I'm going to go ahead and dive in and I'll monitor the chat as well. And then at the very end of our conversation, which I'm hoping about 30 minutes or so, depending on the questions or not, or if we do have them or not, I'm going to give you DJ and Dana's contact information so that you can reach out if you have other questions. All right. Hi, Linda and Myra from Columbus. Hello, Atlanta. Okay. So we're here, as parents and caregivers of teens and adults with developmental disabilities, we are faced with so many challenging decisions. I mean, it starts from when they first get the diagnosis all the way through school and then post high school. There's just so much to consider and think about. So I'm going to start with supported decision making. And so as our self-advocates become adults, it's important that we have these conversations as a family. And so I'd love to just introduce Dana to talk a little bit about the core elements of supported decision-making.
Absolutely. Thanks for that, Rita. I'm so happy to be here with you all tonight and have this conversation. Supported decision-making and other alternatives to guardianship is one of my favorite things to talk about. So the first thing I like to say about supported decision-making is that it is human decision-making. It is the process that we all use to make our decisions. We think about this for folks with disabilities to kind of give the process a little bit of structure. But if you think about a major decision you've ever had to make, buy a car, buy a house, move, start a job, have a major medical procedure, you wanted to make sure that you got all the information in a way that you really understood. Maybe some of those jargony things, you wanted someone to help break them down for you. You wanted an opportunity to think it over with people in your life you trust, who maybe know you well, or maybe who have experienced that process before, get some tips and advice from them. You wanted an opportunity to think about what your options were, to kind of weigh those options against each other, think about the risk and benefits and impact. And then you may have wanted or needed some support to communicate that decision to other people. That is the process of supported decision making, using folks you trust to gather information in a way that works for you, um, having the support that you need to weigh out those choices, really think about the consequences, um, and then communicate that choice to other people and have folks support you in that, right? Um, and the other element that I think really goes along with this is understanding that decision making is a skill that can be taught. It's not a static capacity. We don't believe that people have the capacity to make decisions or they don't have the capacity to make decisions. Decision making improves with support and with teaching and with opportunities to practice those decisions and experience things going really well from your decisions or maybe not going so well. But those are the things that I think of as the core elements. Um, Getting the information in a way that works for you, having an opportunity to run that through with people you trust. And sometimes that might be professionals, right? If we've had to consult an attorney like DJ or a realtor or a mechanic, right? We do that. We get professionals to help us out if need be. And then having the support you need to run through what those consequences or benefits might be, and then communicate that to other people. I think those are the core elements of supported decision making. That's what we try to help parents and folks understand.
Thanks so much, Dana. And I want to mention again, this goes without saying, this interview tonight, we're not giving you legal advice or we're providing this information. It's general and educational in nature. If you happen to be watching and you're not in the state of Georgia, please consult the rules, regulations regarding guardianship and some of the legal terminology you're going to hear by connecting with an attorney in your state. So yes, we are from Georgia. And DJ, guardianship. And let's talk a little bit about that. And then also other alternatives that we may not have thought about. So is guardianship from a legal perspective when our folks become adults our only option? And tell us a little bit about it, please.
So it's not your only option. Of course, guardianship is the legal process by which your county probate court removes rights from your child, who's now become an adult legally at 18, and revests those rights with the parents. So the parents will continue to exercise the rights, almost like that child was kind of frozen in time at 15 years old. That is not the only option. The other major option, of course, there's supported decision making, but in addition to that is powers of attorney. Now, powers of attorney, no rights are removed from the child. What it is, it's the legal process. It's a contract process where the child essentially appoints the parents or whoever they want as their agent to exercise the child's authority in the child's name. I keep saying child, but we're adult child.
Yeah.
And so that process does not get the court involved in your life. It's something that I would encourage you to go to an attorney for. Everybody should have powers of attorney. It's basic in any estate plan. I have them. My wife's my agent. It allows the parents to exercise things like healthcare decision-making, financial decisions, really anything. The thing to understand about that is the parents work for the child. The child's the boss, and the parents are the child's agent. And so ultimately, if the child shows up and says, nope, changed my mind, well, mind has been changed. It does not matter what the parents said. And so, there's a different level of control, essentially, that the parents would have, more so with guardianship, less so with power of attorney.
Okay. Okay. So then what would be the difference legally between power of attorney and supported decision making? What's the difference there? Yeah.
That's a great question.
So,
Go ahead, DJ.
So legally, power of attorney, the court's not involved, it's contract. Okay. So legally, the child still has all their rights and saying, hey, mom, hey, dad, I'm empowering you to call my doctors, to deal with my banks, to deal with my accounts or my benefits. But the child still has all their rights.
Okay.
In guardianship, those rights are removed from the child and given back to the parents. That's the big legal difference between the two.
Okay.
And in supported decision making, it's similar to power of attorney in the sense that it's a non-legal process, right? But within a power of attorney arrangement, the child is naming this agent and giving them the ability to make decisions on their behalf. And in supported decision making, as a person with a disability, I'm retaining that and I'm making the decision, I'm implementing the decision, but I'm getting support to do that. I'm getting counsel and advice. Now, people can and often do use supported decision making for the decision making process and still use power of attorney for the implementation process, right? In Georgia, supported decision making isn't statutorily recognized. We can talk more about that. We don't have a supported decision making law. There's not a piece of legislation. So sometimes people still run into what we call third party recognition, where the doctor's office is a little nervous about accepting the decision that the person's made with support, or the bank is, because people still may choose to use power of attorney within that context. But the process of supported decision making is the process by which the person with the disability makes their own decision. There's no substitution. There's no sharing of decision making. I make the decision, but I made that decision with the support I needed to get there, to get to that finish line.
Okay. So thanks, Dana. So a question from Facebook: are powers of attorney legally accepted by the medical community?
Absolutely. And again, that's something really everybody should have if you have additional needs or not. You want to make sure somebody is empowered to make your medical decisions if you become incapacitated. In the special needs community, it's a little bit different. It's drafted a little differently in that most children will want the parents to have the ability to speak on their behalf for medical decision making, even if they're not incapacitated. More, as Dana said, as a convenience, child makes the decision, hey, mom, dad, I need you to coordinate with the hospital or coordinate with the bank. So it's absolutely accepted in the medical community.
Okay, so I'm going to start with medical. I'm seeing some questions here on the side, and I will get to those. Tracy and Rita, this is applicable to the medical community. Do you need to be able to prove that to the medical community that you have power of attorney? Do you have to be able to prove that?
If you're going to exercise it, yes. I mean, because otherwise they're going to say, hey, what gives you the authority to make these decisions for this adult, this other adult, even if that adult's your child? What I always suggest, if you do have power of attorney, if you don't have a paper copy with you stashed in your car or something like that, take a picture of each page with your phone, because we always have our phones with us. And a lot of medical providers will accept that picture of each page.
Okay.
You
So
could
that's
also upload a copy of that document to like your electronic health record, right? So if you see a doctor at Emory and generally get your treatment from, say, Emory, then that health record would have that document. So you can also use some technology to kind of keep it with you at all times. But yeah, absolutely, folks are going to want to know that you are indeed the agent. So you'll need to have some proof of that.
And so, DJ, in terms of guardianship, is there anything about medical decisions that we might need to know in terms of speaking with doctors, any type of surgery, medications, I think. So if someone does decide to go that, more significant route of guardianship, what do we need to know about the medical decisions there?
Well, so the big one is the ability to consent to medical treatment is removed from the child and given back to the parents. So really, again, freezing the child in time at 15, essentially what the parents decide goes in terms of medical treatment. There are certain types of treatment, which I don't want to get too far into the weeds, but things, in terms of reproductive rights and things like that, which are kind of different.
Yeah.
But ultimately, the buck stops with the parent in guardianship, and they make the decisions.
So Beth is asking here, well, I've got a couple questions. In the worst case scenario, in an emergency room or planning for surgery, will the medical team in Georgia accept a POA 100% of the time?
I can't speak for every medical team in Georgia, but they should. It's a legally binding document. Georgia has a statutory advance directive, which doubles as a medical power of attorney. And so what I suggest is that you use something like that or something modified for your situation so that it's instantly recognizable throughout Georgia if you show it to an ER doctor or any hospital or medical team.
Okay. Thanks, Beth, for that question. I also think worst case scenarios, so that's important. Myra says, hope I got your name right. Can more than one person have POA?
Yes, absolutely. It can get confusing because if you have multiple agents on one document, you have to be very careful to define whether each agent has 100% authority or whether those two agents have to agree on everything.
Okay.
And that's a big, big difference. That can cause some confusion with whoever you're presenting the POA to.
Yeah, absolutely.
So Dana, in terms of medical decisions, this goes without saying, I know that we know the answer to this question, but in terms of supported decision making, is there anything that we need to consider if someone chooses to go that route?
Yeah, absolutely. I think one of the things that I think is sometimes confused in guardianship, something that folks sometimes ask us about is I really think I need guardianship because this person that I care about is not complying with treatment, right? Won't go to a doctor's appointment, doesn't want to take medication. And guardianship can't force those things. People can still object to certain treatment and to medication, right? And so it's important that if you're going to consider guardianship, that when you're consulting with an attorney, you ask those sorts of questions and you are really clear about what guardianship can and can't do. I think that we sometimes talk about kind of myth busting guardianship, right? That people have some preconceived notions that guardianship is a bit stronger than the statute actually allows. And so with supported decision making, all of this is coming from a strength-based perspective, that if we can build the person's strengths to understand their medical condition and why the treatment is being prescribed and how they can participate in that treatment and how they can safely object, right? To be able to say, I'll use myself as an example. I just left a doctor's appointment today where I had to talk about a medication that I was like, I don't think I need this. Here's the evidence, right? Of why I think the other things that we're trying are working well. Because of having the support and the information to be able to do that, I'm able to advocate for myself. And instead of just fighting back and refusing the treatment, I was empowered to get my doctor to say, okay, I see your case and we'll check again in a certain period of time. So the process of supported decision making is to help people build that skill and to get support when they need it, right? So perhaps you're thinking, I don't know that my son or daughter could navigate that conversation Dana just talked about on their own. Well, people don't have to be able to navigate that on their own. Can they navigate it with you, right? And can you be the supporter that's helping them communicate that decision to the medical professional? So I think when it comes to medical decisions, that's one way to think about it, is we're trying to build the skill for the person to have their own kind of empowerment around that. And the other thing I think about that folks sometimes contact us about, that I don't often think of as an alternative to guardianship, but it can kind of work that way, are just simple releases of information, right? The fact that if what a parent or even a person with a disability is concerned about is that I have to go into this doctor's appointment by myself, take in all of this information, remember everything that they tell me, and then go do that in my life, and I don't feel prepared for that. Well, a release of information, a HIPAA release, would be able to say, I want my mom, dad, sister, aunt with me, right? They can help to process some of this information and help me continue to implement that decision when I'm leaving the appointment, right? So sometimes people just need space to get in the room, and something like a HIPAA release for medical decisions, or educational decisions or financial decisions, the release of the information can keep the information flowing so supporters are able to help the person then trade on that information, implement those decisions. And then the last thing I will say, that folks are often kind of worried about that emergency situation, that worst case scenario. Georgia also has something called the medical consent statute that lays out for everyone that is a Georgian, who can make a decision for you in the event of a medical emergency. And it starts by saying whoever you appoint, which is why we encourage people to have powers of attorney and advance medical directives. And then it lists an adult child, right? So if my child is an adult, they can make that decision for me. My parent, no, sorry, my spouse or my parent. That is the list for any of us that are on this call. If we were to have a medical emergency right now and we had not made any determination, then those emergency treating physicians are given instructions in the statute of who to follow in that emergency situation. So I've had some parents tell me that felt like a little bit of a safeguard, right? It was a little bit of a stopgap, because their children did not have adult children, or were not married. That parents being number 3 on that list helped folks to think through, as we're trying to build this skill of decision making, there is a bit of a stopgap.
Thank you, Dana. We have lots of questions here. I promise I will get to your questions. I really want to get to the contract piece though. So what if, someone who doesn't, well, I won't go through a scenario, but what's the difference in terms of being able to sign a contract? So buying a car, buying a house, credit cards, that type of thing. If you have guardianship, DJ, are any of those things possible? If you have power of attorney, can an adult with DD go ahead and, get a credit card in their name or a loan in their name?
So with guardianship, the right to enter into a contract, to make a contract, modify a contract, that's all removed from the adult child and given back to the parents. So if that child goes out, there's guardianship in place, the child signs something, it's void from inception, like it never existed. With power of attorney, as I said before, the power to contract remains with the child, but the child can also authorize mom and dad to go out and enter into contracts on the child's behalf. That doesn't mean the child can't do it themselves. So if the child goes out and signs on the dotted line, it's presumed of a contract, it's presumed to be a valid contract. And I will tell you from my judicial experience, courts are really reluctant to let people out of contracts for just saying, I didn't understand what I was signing. Okay. And so, we just have to be really aware that if you have an adult child, there's power of attorney in place, and they're out, not supervised by whoever they need to be supervised by, and they sign something, now you can get out of it. You can get out of it, but you're going to have to go to court, and you're going to have to prove to the judge that that child lacked capacity to even enter into the contract. And I will almost guarantee you that judge will say, why isn't there guardianship in place if they lacked capacity?
Okay.
So you got to be ready to answer the question.
That's tough. That's tough. Dana, anything you want to add to that?
Yeah, I mean, it's, in some ways, I feel like it's kind of the same answer in a different scenario, right? That what we try to help people understand is, I think about what keeps us all safe, right? Is being able to um, kind of determine danger, right? And so we work with people in the process of trying to teach supported decision making about kind of what the setting should be before you're entering into a contract, right? Did you read this? Did you understand this? Were you pressured? So that folks kind of are able to fend off those situations where this might be a contract that they're thinking about entering into, without all the information. And then also, I mean, I agree with DJ in the fact that, I think even in the situation where there's guardianship in place and someone has signed a contract, legally that might be void from inception. But you're probably still going to have to go through a process of proving that, right? And that we've supported folks who are kind of fighting, that process. It wasn't just like oh, well, by the way, that you're fine, you're off the hook. So I mean, I think the protective factor of helping people understand um, how to and not enter into contracts is helpful, because there's no, in my experience, there's no kind of silver bullet, right, that just wipes those things away.
So Dana, would this may be a long a question that may take too long to answer, but so you have a group that does this sort of training of self-advocates, or how do they get that training to understand?
Yeah,
Is
that's
it
a great.
the supported employment, the supported decision-making group, that team? Do they do it together, or how does that work? Is there a
That's
structure to it?
That is a really great question. So I'll give you the shortest possible answer I can give you, which is our office will give anyone who contacts us the very basic information about supported decision making, some guides and tools via our website. There's some great resources from the ARC National. We'll give people information. We host information sessions. We'll come out and talk to folks to help them understand the process of supported decision making. We are not we don't have the capacity, right, to go work with every individual family to help you build your supported decision making plan, but we'll do some troubleshooting with people. We'll try to answer questions and get things going. We also have parents. We have a parent community of practice, so other parents who've been helping to support their child using supported decision making that folks can call and consult with and can do a little bit more of that guidance. We also have young adults themselves who are using the process of supported decision making that will do that same thing, right? Answer questions, try to guide people through the process. If there is a situation where a person is vulnerable to a bad outcome in some way, shape, or form, we have supported people in individual advocacy to deflect from guardianship or get their rights restored or enact a supported decision-making plan. We had a judge call us once and say, I have a petition before me. I don't think this person needs a guardian. Can you help this family create a plan that I can kind of initiate instead of this guardianship. So in those kind of high risk situations, we will offer that one-on-one support. There's a ton of resources on our website. We're working on building out this upcoming year some more resources so folks can get some more of that type of one-on-one support. So yeah, idecideGA.org. You can use the contact form to get in touch with those parents or those young folks themselves that would want to consult with people. But that's primarily how we do it. But we assess each situation as it comes, right? So if folks have a real specific question or a real specific need, we're willing to think about how at GAO we can support them to get their supported decision-making project off the ground.
Great. Okay, so folks are really anxious probably. There's so many questions here. So folks, I'm going to get to your questions. I promise, absolutely next. I really want to get to the law enforcement piece or any type of legal interaction. So if someone, hopefully this is not going to happen to anyone that is listening, but should someone have an interaction with the legal system, law enforcement, etc., and they don't have guardianship, can the family talk to the legal system, DJ? Or is that possible? Or what happens if there's nothing in place?
So generally not. If someone enters in the legal system, they get an attorney, a public defender, or a court-appointed attorney assigned to them. That attorney's very first thing they tell everybody: don't talk to anyone about your case except me. And so, can that attorney-client privilege be waived by the child? It can, but there are always risks associated with that. My bigger issue with law enforcement, and that is the majority of what I do through my judicial work, is work with the DA's office and law enforcement and criminal defense attorneys. And I've asked them this question because I give presentations like this where we talk about guardianship, POA, and supported decision making. And I've asked them without any preamble that, look, would it matter to you if a defendant came in front of you if there was power of attorney or guardianship? And you have to understand that most of these prosecutors are looking at a case and they're used to people telling them things to get out of trouble. And so there's always a little bit of a skepticism, cynicism on their side, which I understand. But every single one I've spoken to, and I will confine this to Gwinnett County, every single one I've spoken to said power of attorney would not matter to them. Because, as we said, kind of said in the beginning, everybody should have it. It doesn't really say anything. They said guardianship would absolutely make a difference. And they said that because a court of competent jurisdiction has already adjudicated the fact that child has some inabilities to make decisions. Included in that might be the ability to comprehend or form the intent to commit a crime. It becomes very complicated. And most DAs, when they see that, just say, look, this is not, we're going to exercise our discretion. This is not, a repeat offender. This is a one-time thing. We're going to decline to press charges provided, mom and dad get the child counseling or something. So, there is protection. And I will say that I don't think power of attorney or supported decision-making in and of itself offer any legal protections. None.
Okay, so if you have an individual, if you're supporting someone and that is, let's say, nonverbal, someone, Amber says, doesn't communicate traditionally, then should we be concerned, Dana and DJ, if this should ever happen? Hopefully, again, it will never happen, but you just don't know in our world, right?
Yeah, and I'm open. I hope DJ corrects me for anything. I am not an attorney at all. I spend a good bit of time with our litigation team. What we counsel people to understand is that the determination of competency and capacity in a civil case, right, in a case around guardianship, is different than that process of determining capacity and competency in criminal action. And we've been asked to represent people who were facing criminal charges and had guardianship. So yeah, I'm not going to disagree that support decision-making and power of attorney might not provide much legal protection. But I also, we haven't experienced guardianship providing total legal protection either. Especially, and that might be a thing where in the end, that is where things land, but have people still been arrested? Have people still spent time in jail? Have people still gone through a process? Even with those things in place? Absolutely. And I think to the point around folks who don't communicate traditionally, I don't think that it's a useful tool to say all people who and fill in the blank, right? So absolutely, do we support people to use supported decision making who don't communicate traditionally? Yes, absolutely. Do we support people who would be seen as very impacted by their disability who use supported decision making? Absolutely. I don't think that there are alls and nevers in this process. So I think it's about knowing the person that needs the support, thinking about if decision making is a skill, what have we done to teach that skill, support that skill, offer opportunities to learn that skill, to practice that skill, and to think more about what would it take? What might it look like? I won't go into telling like a big long story, but um, you know, there was someone who their residential provider needed to move, right? The person who owned the group residents needed to move. And they just told everyone, we have to move, you have to pick another place to live. And that's a big decision, right, about where people want to live. And so someone contacted us to say, hey, can you help in this situation? We don't think people should kind of be treated this way. And one of the things we did was just ask, like, how much time do people have? Can we go visit these other locations? Is there enough time to go visit the other location? Because that was kind of how it was reported to us. It has to be immediate. Well, immediate was about 2 weeks. That's fast, but it's not immediate. It's not tomorrow. Could we have conversations with people about what was important to them about where they lived? This one young man worked and had a group of friends and went to church, and all of those things would matter about where he lived. So it was just the process of taking this big decision, slowing it down a little bit, getting real time frames around it, and then looking at what are the pieces and parts of this process. Do I believe that a person who doesn't communicate traditionally could have been involved in that process of helping us know what's important to them about how they spend their day, and go see a place and indicate choice and preference? Absolutely. I think that's possible. Absolutely. I think that we can do those sorts of things. So I don't think that it's an always or never kind of process. I think supported decision making is very individualized, and works to answer the question based on the perspective of the person who needs that support making decisions.
Thanks, Dana. Tracy's been very patient, so I'm going to put her question up. I have sole custody of my child. Do I have to share guardianship with my ex, or can I be the only one?
So you can be the only one. I think, certainly if you file for guardianship, it is that courts and your ex intervenes in that process and wants guardianship himself or wants co-guardianship. The court's job is to make the best decision in the interest of that child once the legal standard has been met for guardianship. Most judges we've appeared in front of do not like to have exes as co-guardians because there's some inherent, usually, not always, usually some animosity or conflict there. And, courts realize that and just understand that's probably not the best idea.
Okay, great. All right. Thank you, Tracy. I hope that helps. Okay, let's see what else we've got here. Does the power of attorney have to be renewed periodically if there are no changes? Do you have to do it, or when does it have to be renewed, or does it have to be renewed at all?
It all depends on the terms in the power of attorney document itself. Most of them are called durable powers of attorney, which means it will survive going from having capacity into incapacity, and have no time frame for termination. So it can continue forever if that's how it's drafted.
Okay. All right. Thank you for that. Let's see. All right. Here's another one. And then we're going to go ahead and wrap up because I've promised DJ and Dana 30 minutes and now we're at 39. But I want to thank all the people that are hanging in because our attendance, our participation has not dropped. Actually, a few folks have joined. So hello, does joint guardianship automatically default to the other person if one of the guardians passes away?
So it depends on the county. And each county handles it differently. Many of the counties will just say, look, you need to file a petition along with a copy of the death certificate of the other guardian, and then we'll reissue letters of guardianship in that other co-guardian's name. What you won't have to do is go through the entire process to prove that the child meets the legal standard for having a guardian. But so it may not be automatic, but it's not redoing the whole process.
And I think this will be the last one. So I'm in order of least restrictive to most is supported decision-making, power of attorney, and then guardianship. Would we say that is correct?
That's how I tell the story, right?
Yeah.
All right.
That
So, Sandra, you got it.
Yeah, I think of supported decision making as an accommodation to making your own decisions. It's glasses, it's a ramp in the door, right? It's the tool that the person uses to make their own decision. And so then any other process whereby, even if we're sharing decision making, even if it's we think of power of attorney as a really useful tool, right? But anything in which my decision making gets impinged a little, that's a restriction, right? And so then for sure, guardianship, which removes my decision-making rights fully, would then indeed be the most restrictive.
And I do with the concept of impinging on the right to make decisions, I do want to put out there, and I talk to clients about this regularly, that the concept of supporting decision-making, not supported decision-making necessarily, can be initiated within guardianship. That can be initiated within power of attorney. So just because as a parent you have guardianship over your child doesn't mean you can't sit down with them and take the time to explain the pros and cons of making good decisions. You can still do that. So it's not that all of these are, I'm making one choice and nothing else has any value. They all have value.
Thank you, DJ. That's important to know as we're really struggling with all of these decisions. So if you want to get in contact with Dana Lloyd, here is her email address. And again, for those that are watching live or those that are watching on the replay, we thank you so much for joining. If you'd like to get in touch with DJ, here is DJ's contact information. All right. And again, thank you all so much. Thank you, Dana. Thank you, DJ. This has been a fantastic conversation. We've had about 50 or so folks join us the entire time, so appreciate it so much. And everyone, just know that we support you in the decisions that you make, and I'm trying to provide information for families of adults with IDD and create a safe space to really struggle with all of this. Thank you so much, and you all have a wonderful evening. Take good care. Bye-bye.
Good night.
Good night.